So please unmute yourself and say whether you're present or not. So Bashan,
Present.
Hamilton,
Present.
McRae,
Present.
Alvera,
Present.
and Zarush.
Present.
Thank you.
All right, so I am going to make a recommendation that today we do not start off with public comment, and I'll explain why to the subcommittee members, and any of you that object to that, let me know. But we have three sets of speakers here in response to where we left off at our last discussion about in-court representation. We've got Steve Crossland, and I'm not sure, Steve, if Renata is here, but we do have at least Steve Crossland from the Washington program. We've got Dave Byers from the Arizona Administrative Office of the Courts, and then we have Bonnie Huff from the Judicial Council to talk about the Self-Help Center, sort of statewide perspective. Steve and Dave have some time constraints, so I'd love to hear from our speakers first, and then maybe take public comment and segue into the discussion if that works for the group. Does any one of our subcommittee members object to that approach? Is anyone raising their hand? Linda, right? Okay, great. And just a heads up that I do myself have to jump off at 2 o'clock, and Linda's going to take over for me then facilitating. So I think first up, Steve and Renata, if she is on the line. From Washington, did we get the Washington bench card shared, Linda, with the group?
You know, we did not get the Washington bench card out. I apologize for that.
Okay, so why don't we get that to the Dropbox, and we'll also get it posted. But Steve did provide that. Steve, why don't you take it away and talk about the in-court representation and the Washington program, some of the background on that, and then the bench card, which we will get out to the members of the working group.
Great. Well, thank you. Thanks for allowing me to participate in this. And do you want me to just talk about the in-court representation?
Well, that's the focus for the group's discussion today. I am trying to take us from where we left off last time. I'm sure working group members may have other questions for you, but if you could focus your initial remarks there, and then of course, folks might have questions for you about other aspects of the program.
Sure. I mean, I'd be happy to tell you the whole history, but it's a long time. I got an email from Hanada. She said she's trying to get on, and with regard to the bench card, it would be helpful if she were to be able to get on it, because I think she was a little more involved in that than I am. With regard to the in-court representation, when we first drafted the rule and submitted to the court, we had to draw the line of what we thought would be reasonable to be accepted by the court and lawyers. And, you know, there's been, as you know, a lot of opposition by lawyers in the state of Washington and, well, all over. But so we decided when we drafted the rule that maybe going into court and representing and actually looking like a lawyer maybe was going too far and would not be palatable. Once we began licensing triple LTs and having them represent people, it became very problematic to us that they could not appear in court, and for everyone, for the triple LT, for the client, most importantly, and for the court. And we realized that it seems sort of ludicrous for the triple LT to have done all the work in preparing the case, filling out the forms, getting them into the court system and having the hearing, and then have the triple LT have to either stand outside the door or sit in the courtroom and not answer any questions. So we went to the Superior Court Judges Association, which is the highest trial court in the state of Washington, and talked to them about this. And in fact, I spoke to them, their executive committee, this last spring, and they were unanimously and overwhelmingly in favor of the idea of appearing in court, because as they saw, this made their job a whole lot easier. They had historically been faced with having their calendars clogged with pro se clients who didn't have the forms prepared, didn't understand what the process was that they were getting into. And so they really favored having the triple LT be able to appear in court side by side with their client. At this point, it had never been our intention that the triple LT would be arguing cases or putting on trials. Rather, we thought that they could be of great assistance to the client and the court to be able to be there to say, why did you choose this form? Why did you fill in this form in this fashion? And more importantly, to just give the client moral support. I think appearing in court, even for lawyers, is sometimes, at least young lawyers, is sometimes a daunting experience. And I think, when clients, in our case in the state of Washington, they're going through a divorce, there's a whole lot of stress that they're going through anyway. And so I think the better we can make that process for them, I think the better for everyone. So that's kind of the reason that we approached the court about having triple LTs be authorized to appear in court. Now, in that process, we asked the Superior Court judges to help us prepare a bench card, and you'll get a copy of that sometime soon, just so that all the Superior Court judges were on the same page about what the expectations were of the court and of the triple LT in appearing. It had been my hope that I would be able to appear, or somebody from the triple LT board would appear at the annual meeting of the Superior Court judges to put on a panel and explain about this, so that we have 39 counties in the state of Washington, and my dream would be that they're all somehow unified in the expectations about what triple LTs can and can't do in their courtroom. Also at that executive committee, there was somebody from, one judge from our district court, which is the lower trial court in our state, and they said, well, why don't we get triple LTs in our courtroom? We could certainly use them. And we've been approached by the State Prosecuting Attorneys Association to allow triple LTs to participate in actions that they have. So I think the opportunity is great. We were also approached by the chief administrative law judge and worked with us this last year, trying to put together a practice area that would be able to have triple LTs appear in administrative law courts too. Now, lay people can appear in Washington in administrative courts, but I think the administrative law judge, the chief anyway, felt that if they could have people that were uniquely trained, that they too would have a better process and everyone would benefit, the court and the client as well. So that's, in a nutshell, that's kind of where we are with regard to appearance in court in the state of Washington.
All right, thank you, Steve. And I think Renata was on and then she dropped off, so I'm not sure.
And I just got an email from her saying that she can hear us, but she can't speak. I saw her, promoted her to panelist, and she disappeared, and now I cannot locate her among the attendees.
She can hear, but can she speak? I mean,
well, she could speak if I could promote her to panelist, which I had attempted to do, but now she just seems to have vanished. And I have an email back with her. And also, I realized I had posted the Washington bench card to the Dropbox. I'm going to send it to the group now.
Okay.
So do any subcommittee members have questions for Steve? And if we are able to get Renata on, we will do that. We could also screen share the bench card if you all would like to take a look at it, because it does provide some specifics around what the triple LT is authorized to do and not authorized to do in court. No questions? I don't see anybody.
I've got my hand raised.
Okay, go ahead, Steve. Sorry.
Mr. Crossan, how long was the LLT program in effect in Washington before the change to in-court work was approved?
Well, the rule was passed in June of 2012. We began work in January of 2013. The rule was approved. And And I don't think we had our first licensed triple LT until probably 2016, because it took a long time to develop the foundation of the program. And I think the court approved appearance in court in 2019.
So about a 3-year lead time before they made that change. And were they being allowed to, or are they being allowed to argue cases or answer questions from judicial officers?
Not argue cases, except if there's a misunderstanding about what they're trying to present, but yes, especially to answer questions from judicial officers. Exactly.
Okay. And then did they, were they prompting their clients on evidentiary objections or making the objections themselves during an evidentiary hearing?
Well, yeah, I think they could. I mean, they're going to prepare their clients as best they can for the experience that they're going to go through in the courtroom. But I don't know about objections to evidentiary information. These cases are generally uncontested. They're just processing these cases through.
Okay. I guess that's one of my questions. Were they being allowed to act as de facto attorneys in cases where the other side had an attorney representing them?
Well, to the extent that they're able to appear in an uncontested with a pro se client, otherwise pro se client, yeah.
Okay. So just so I'm clear, the rule was they could appear in uncontested matters, but in a contested evidentiary hearing, they were not appearing.
That's my understanding, right?
Okay. Thank you.
Mm-hmm.
Any other questions? And I don't think we got Renata. Would you all like us to put the bench card up now? Linda has sent it to you. Hold on.
Just to bring you up to date while we're having documents processed, a couple of things that have developed recently with regard to the status of the license in Washington. As you know, the court summarily sunsetted it a couple of weeks ago, and there was an editorial in the Seattle Times, the largest paper in the state, strongly recommending that the court reconsider its position. And there was also an article, I haven't completely read it yet, in Above the Law that was circulated today, also strongly recommending the court to reverse their position. So we'll see.
And I've got the bench card up on the screen. And again, you all have this in your email. I think it's a great model for what you may ultimately want to come up with, even applicable across practice areas. Okay, thank you, Steve. And I think with that, we can turn to Dave Byers. And if Renata is able to join us, we'll have her talk a little bit about a little bit more further about the bench card and its development. So Dave is with the Arizona Administrative Office of the Courts.
Well, thank you, and good afternoon. So I'm the director of the Arizona courts at the state level. A little background, for over 15 years, we've already had approximately 700 legal document preparers that are licensed by us at the court. So they do all the things that triple LTs do in DC, or in Washington rather, probably more, with the exception that they don't give legal advice. They're not authorized to give legal advice. They can give legal information, and I'll have to say it's pretty gray between legal information and legal advice. Currently, the the licensed document preparers don't go into court to represent people. However, they sometimes have gone to court, sat in the back, and judges have called them up to assist. So in looking at those, and I should also tell you that self-help centers that you have in California, those actually were invented here in Arizona. Many years ago, decades ago now, in Maricopa County was the first one. And they're terrific. They do a lot of good work, but we observed over the years that there are a large number of clients that go through those self-help centers, and then they just are not able to go into court and advocate on their own and present their case effectively to a judge. And so like most states, we have a free-for-all in our family courts. 80% of the people are not represented in Arizona now. So this isn't a matter of having lawyers or not. It's a matter of you're on your own or having a paraprofessional. And after years of watching this go on and seeing these people that are going through a very traumatic situation, plus our experience with our licensed document preparers, I should mention to you that per capita, we get less complaints on the document preparers than we do on lawyers. It's just a factual matter. And we get very, very few complaints about the quality of work or the work product from the consumers. So our task force recommended that we create a new level of a legal provider, that being a triple LP. And the easiest way to look at it is it's like a nurse practitioner. These triple LPs, if our court approves them later this month, will be tested, have to have experience, but then they will be able to go into court and represent clients in limited areas. So they're not getting the same law author, they're not bar membership that a lawyer does, who in our state, like yours, can then practice in any area. They will only be able to practice in limited areas. The area I think you're interested in today is family law, and they will be able to go into court and advocate on behalf of their clients. Now, most of these are not trials, but you could have a contested issue. There's no doubt about that, either between two pro se's or lawyer or two triple LPs at some point. But we also see this, we have a lot of non-lawyer mediators right now that mediate the couple's divorce decree and often can get everything settled except maybe one or two issues. Some of those mediators are document preparers, and they can fill out all the documents now and send it in. But when you have to still go in and the clients have to advocate, say, let's just say it's spousal maintenance, they're still back into a lot of drama in court, not being prepared. And we envision that these mediators could get certified to be a triple LP and now go in, as long as the parties have waived the conflict, and present to the judge in a non-emotional, factual matter. Here's the situation, here's the evidence, here's how long they've been married, here's their income. Now judge decide. They can't agree, you decide on this issue. So our triple LPs, we do envision they will represent folks, they will be able to advocate for folks, they will be able to answer questions. What they won't be able to do are two things, at least initially. They're not going to be able to process a quadro unless they have experience and take a special exam that shows they're qualified to do so. Now, I know a lot of lawyers don't do quadros either. They farm that out to a CPA or someone with expertise. And the other area we've limited is if there's going to be a transfer of a business. So couples divorcing and it's a dentist or they've got a business. We've carved that out to say, no, they can't do those transactions. But otherwise, they'd be free to process a divorce. And in our state, at least 50% of the matters in our family court are post-decree. And as you all know, people argue over everything, what time to pick up John, all sorts of issues around the parenting plan. Most of them are not complicated legal issues, but there are disputes between the formerly married couple. They'll be able to do that work also. So with that background, let me just pause because I think Leo wanted me to make sure we had time to answer questions, and I'll just pause and answer any questions that your committee might have.
Any questions from the group? Stephen.
Mr. Byers, how long have there been practicing paraprofessionals in Arizona?
Well, the group I mentioned, the licensed document preparers, have been in business for 15 years. But I'll tell you, we have other groups. We have Rule 31, which are all the people who are non-lawyers who are authorized to practice in our courts. There happen to be 31 different groups, tax specialists, and just like in California, I'm sure the courts have allowed a number of non-lawyer folks to go and represent people in our courts over the years. Then we have something unique, and I don't know what California's status is, but 50 years ago, our court ruled that to do real estate transactions, you had to be a lawyer to write a contract, modify a contract title, to convey real estate. Well, the real estate folks didn't like that, and they went and did an initiative, just like you have. They passed that. 80% of the voters supported authorizing a change to our Constitution to allow real estate agents to practice real estate law. And so we've had 50 years of real estate agents, also non-lawyers, practicing law in this area, real estate law. And frankly, we've looked back on that and we have no major problems. So we've had people for a long time who are non-lawyers practicing law in various areas, real estate, tax, representing corporations or businesses, a variety of exemptions, and then 15 years of the document preparers.
But this particular program, Dave, the Triple LP, that particular program has not yet launched. This is the
the rules are pending before our court in about 2 weeks. And so if they approve this new tier, it'll be new and probably won't be up and running until I'd say the first of the year.
And part of its initial launch is going to include in-court representation?
Yes. Yeah, another factor, when we went through this with the task force, a number of our triple or our licensed document preparers are also
Is it just me that can't hear?
No,
Dave?
we lost him.
Okay. Dave, we can't hear you. Can he hear us?
Am I back?
You're
Yeah,
back.
you're back
Yeah,
now.
I'm sorry. Occasionally, I don't know what it is on Zoom. This computer cuts out. Wave at me if you lose me. A number of our document preparers are also certified tax specialists. And they've been allowed for years, decades, to go in and represent clients before tax IRS authorities. And so we have some, and a lot of these people came in and testified to us, that are doing non-court work as a document preparer, but then they're going in and actually advocating and representing clients before IRS. So they've worked well. So anyway, I just pass all that along to you.
And then one other question, is there any kind of client security fund?
Yes.
Okay, how is that funded in Arizona for the?
It's a fee, I think it's about a $15 fee. It's paid with the dues that's tacked on to the lawyers. And what the plans are is to modify that trust to include triple LPs if they're authorized, and they would also pay into the trust.
Would you be using the attorney fee payments to fund the trust for the triple LTs?
Yes.
Okay.
It would just be, they would just join. The way we've set up our structure is these triple LPs will become adjunct members of the bar. They'll have virtually the same ethical code, same CLE requirements, and the bar, the same discipline system will investigate and prosecute these triple LPs. And then they'll go into the trust account. We do have limits on those. There's various limits of claims and that kind of thing, but they would all be in there together.
Okay, Fariba.
Hello, thank you for this very helpful meeting. I'm learning a lot. So I have a few questions. Earlier you said that these triple LPs will be kind of like nurse practitioners, and I heard you say they'll be tested.
Yes.
Could you explain a little more about the testing process?
Yeah, we've actually put on an RFP. I think the responses are due this week to hire a testing company to develop a test. Now, it won't be exactly like the bar exam. It really is going to test substantive law knowledge. And we're going to have a series of tests, and our triple LPs can apply for certification in a variety of areas. But they have to pass the test, and they have to have education, and they have to have so many years of experience. So there'll be a test on family law. There'll be a test on civil. There'll be a test on criminal law, because they'll be able to practice in lower courts of criminal law. So in order to get certified, and somewhat unlike the bar exam, it will be substantive law in the area that you want to practice in, and you'll have to pass it and be certified for that area. And you could, start out with one area, then later on another, and so forth.
And the oversight will be through your state bar, because I heard you say that they're once they pass the test, they'll become adjunct member of the state bar, correct?
Right. The way it'll work is just like it works for applications to become an attorney. They apply to my office. We do the admissions work. They'll go through character and fit in the same process, same staff, and then they have to pass the exam, show their qualifications. If they're licensed or certified, then they become a member of the bar. They'll be paid, an adjunct member. They'll pay dues to the bar and go through the same discipline system.
Okay, great. One last question. What would you say the differences are between a triple LP and an attorney, other than the attorney goes through law school, and other than the legal information versus legal advice? Because I think that the line between legal information and legal advice is very gray, and a lot of times that could be crossed over, especially if the only limitation is a quadra and transfer of business. So I was just wondering what you thought about the major differences between the two categories.
Well, of course, the major difference is in when you get a bar license, you're able to practice in any area of the law. We don't restrict at all. And so unlike that'll be the big difference. Triple LPs will only be able to practice in limited areas of the legal practice. So they can only deliver certain legal services. I think the thought is that just like in the medical arena, there are now scores of different types of medical providers, most of which don't require a medical degree, that your more complicated and advanced, more contentious maybe cases are going to go to a lawyer. I don't think there'll be a lot of competition, although there might be some competition with like a solo practitioner in family law. But you don't go to a nurse practitioner for brain surgery or cancer. And so we think the harder cases, the more complex cases, are going to go to the lawyers. And yet most of our stuff, 75, 80% are going through, if not by default, with very few, one or two issues for divorce in our court system. So we think those are the types of cases where you have non-represented people they'll gravitate towards the triple Ps. But it remains to be seen. I mean, the market will tell us, right, eventually.
Yeah. I don't know enough about this. I was just wondering if nurse practitioners and physician's assistants can work independently, or they have to be connected with a doctor. I know I love my doctor's physician's assistant, and I didn't see my doctor for 20 years. I always saw my physician's assistant. So I don't know if we can compare that, because I think triple LPs can practice independently, yeah?
Well, a nurse practitioner can practice independently of a doctor. A physician's assistant needs supervision of a doctor. So the physician's assistant's more like a paralegal, where the paralegal works under the guidance and supervision. A nurse practitioner, in our state at least, I think across the country, can practice independently of a doctor, but usually in some limited areas.
Let me just jump in and say we're really lucky the Department of Consumer Affairs finally made their appointment to our working group. And it is the head of the department, the director. And she was formerly the director of the medical board. So she's very, very familiar with the whole articulated structure in medicine. She will be at our meeting in August, and I expect her to be a really engaged participant. The rules around supervision have recently changed and become more liberal, or I think those new state laws go into effect January 1 for physicians assistants in particular. So, but we'll be able to hear directly from the expert on that as she joins our working group. Elizabeth, Fariba, are you done with your questions?
Yes, I'm done. I was just saying thank you very much, Mr. Byers.
Okay, Elizabeth, if I see you have your hand raised, and then Renata was able to join us. So Elizabeth, go ahead.
Hi, this question is for Dave Byers. So I had a question about the fees that the pro-pers, are they paying that directly to the document preparers?
Yes.
And how have you seen that with having these people in the courtroom and helping out, how has that affected the self-help center that you mentioned you guys had previously? Have, you know, can you talk about how
Well, we have self-help centers at virtually all of our superior courts. They're like your superior courts. And they do a lot of work, very busy, it's great stuff. We even have a virtual self-help center where we broadcast, and you could do, training events on how to process your divorce or do an eviction and so forth. We do it virtually throughout the state, and people can attend without physically having to come to the center. All of those things are great, but a lot of people cannot even go to those centers. They're just intimidated or don't have the ability to fill out their own paperwork or know which paperwork to fill out, which form. There are hundreds of forms. It's still very intimidating to a large number of people. So document preparers, say we've had 700 for 15 years, and they renew. So they're making enough money to pay the fee to renew, which is like, I think about $600. And their income, we've actually surveyed, their income varies, and they cover the waterfront of activity. So it's been complementary to our self-help centers where people want to pay usually a fixed fee to get some transaction done by these document preparers. So it's been a nice add-on, I think, for our consumers.
Thank you. Yeah. And then the other last question was, just because these document preparers are there, it doesn't keep anyone from continuing to self-represent themselves, right? It's just basically giving them a choice.
That's right. So especially with the document preparer, they don't have a client relationship. They have a customer relationship. They don't take on the client. They don't go into court typically. You're still self-representing yourself. The triple LPs is a new level where there will be an agreement. They will be representing their clients. That way it's more like a lawyer, but it's more like a paraprofessional, like say a nurse practitioner than a lawyer.
Thank you.
Okay,
when we started this, I was on our task force headed by our vice chairman, our vice chief justice, and I had an open mind. I didn't have an axe to I guess grind one way or the other on this. But boy, the more we looked into in other countries and what they do or don't do, whether it's in England or Ontario, it just seems like where these kinds of programs exist, they're very well received. There are no more complaints against the paraprofessionals, or maybe sometimes less than attorneys. It's just hard to, as a regulator, my court's a regulator, and we have to look at the regulations are there to protect the public, not, I don't want to say this in a hurtful way, but they're not there to protect lawyers. They're there to protect the public. And the more you look into it, you just can't find good reasons to say we should limit the delivery of legal services only to people with a JD degree. And in fact, what we looked at is that society just can't afford it. There's always going to be the need for great attorneys. We've got great attorneys in Arizona, as you do. But the cost, and you all know this, the cost to get through law school is so high now. It's like medical school. You can only afford so many lawyers in the system out there. And the vast majority of our citizens in Arizona, the majority, and I'm not talking about poor, middle class, simply cannot afford an attorney anymore. It's just the system that's been built. And so what we're finding, we had a lot of middle class people come in and even making $100,000 a year and saying, they got 2 working parents, a couple of kids, they're getting divorced, and each side, the retainers were $10,000 each side. And you were talking about taking their kids' college fund or retirement. They just could not afford the cost for lawyers, and particularly if it was an adversarial system.
So Dave, thank you. I'm gonna pause you, and Sharon, I do see your hand up, but I'd like to give Renata the opportunity to speak. Renata, Steve gave us an overview of the sort of in-court representation in Washington. I briefly put the bench card up on the screen. Steve indicated maybe you would have a little bit more background on the development of that bench card. So please do chime in and share with the group anything that you think would be useful to know regarding the in-court representation piece in Washington in particular.
Hello, good afternoon. I think you can now hear me, but maybe not see me. Sorry about that. Yeah, so the bench card was a collaboration. So the OOT board really wanted to provide a roadmap to judicial officers, right, to give some guidance as to what OOTs are allowed to do in the courtroom. So it went through several iterations, drafts, and we got feedback from judges and commissioners. And I just want to clarify, so OOTs, they allowed to answer direct, factual and procedural questions from the bench, but not necessarily put on a case the same way as a lawyer would. And so, they are not entering a notice of appearance, right, in the record. They're just there assisting their pro se client. So I just want to clarify that piece. So the bench card kind of outlines, like given the short amount of time the OOT is going to have over there, to offer this to judicial officers, although we were already able to distribute electronically. But to give an overview of the types of hearings that OOTs can provide assistance on, the limitations, and also to talk a little bit about the background and, the fact that they have to have insurance, professional liability insurance, and they have rules of professional conduct, and where could a judge find out if a OOT is actually licensed, right? Like, so the bench kind of outlines those steps that someone in the bench could then quickly look it up and make sure someone is licensed, that kind of stuff. I'm not sure. Oh, so one thing that I'm not sure if Steve covered, but when the enhancements were approved last year, the OOT board went back and figured out what kind of additional education would be important for OOTs now able to do that, advanced scope to be able to provide the more in-depth assistance. And the board developed a training and made it a required training. So it's part of a licensing requirement that all OOTs, even those that perhaps do not want to engage in this enhanced scope, are still required to obtain. And we actually worked with 2 judges and 1 commissioner, and they were able to provide the courtroom experience type of training, and it was in person last year. And this year, because of COVID, we were able to do it, but it was via Zoom. So just to kind of emphasize that they received training on that enhanced scope, and it was a 2 days full training, and also a component of online training, like several modules that the OOT board put together for them. So yeah, if you have any questions on that, I'm happy to answer.
Thank you, Renata. Sharon, good to you.
Yeah, so I have a question for the Washington program. It seems like at first you did not, or the committee chose not to have the paraprofessionals go into court, and you want to change that now because you've seen that there's a need, and that the paraprofessionals can only help, to a certain point, and then they have to stop, and it's not really serving the litigants. Do you think that it would have been easier to allow them to do that when you first formulated the program versus trying to go in at this juncture to change that?
Well, I'll take a shot at that. Yeah, in retrospect, but I think this was a new program. Nobody had done it before, and I think we sort of picked our battles and decided what we really wanted to address in terms of a strategy in terms of having court approve the rule. But as I mentioned earlier, we sort of early on, after the triple LTs were appearing on behalf of clients, not appearing in court, but just representing clients, that having them appear in court would be beneficial, as I mentioned earlier, to all involved, the court, the client, and the triple LTs. So it just seemed to be a very natural step. Yes, it would have been easier, and I look at Utah, and Utah has 3 practice areas. We chose 1. Would it have been better to choose 3 practice areas? Maybe so. I think that's a strategy that I think we all have to talk about in terms of what the level of tolerance is by the courts or whoever's going to be approving these programs. And I think the fact that we're having this dialogue, and perhaps some of you are aware, there's also a national dialogue going on. We called it a roundtable, that I think we just share ideas and figure out what works, what hasn't worked, or why the dynamics were different. So, Anata?
Yeah, I agree. I think you covered it.
And Steve, you said you had a comment. Did you make your comment?
No. I was going to go back to Dave's comments, which I really endorse, and just amplify them on a little bit. And I think, Dave, maybe my words, maybe yours, but I think this movement really has to do with a change in how we deliver services as a profession. And I think we have all, well, forever, looked at it through our lens. We are going to provide you services through a brick and mortar process, and you come to my office and you take my fees, and that's the way it is. That's not what the world needs. So I really think this process is about having us as a profession walk around the table and view this from the consumer's perspective and say, what do they need? And as Dave identified, there are a whole lot of people, not just poor people, but moderate income people who can't afford our services. And I think the other thing that I'd like to point out is we in Washington have talked about tiers of services. And there are some people that just need information. There are some people who need a courthouse facilitator. There are some people who need a triple LT who's trained in a specific area, but not licensed or trained to go into court. And then there are lawyers who are trained to do the higher level of at least we'd like to think, higher level of services for the clients. So I think there was an ABA convention, a meeting at Stanford about 3 years ago, and we presented on the triple LT at that meeting. And at the end of the meeting, the former dean of the Stanford Law School said in conclusion, I envision a day in which there will be law schools that have 1-year degrees, 2-year degrees, and 3-year degrees. And they're trained to do different things in the delivery of legal services to the public. But it's serving the public is what the focus point is. The other concern I have, and I think it's probably true in all of our states, is I'm in rural Eastern Washington. I'm 73 years old. I don't think a kid coming out of law school today with debt of $200,000 or $300,000 is going to move to a small town. So I really have great fears that the access to justice problem isn't just money, it's access to justice because there aren't any lawyers. And so I would wish that I'll leave you in your consideration of providing access. We'll consider that as a dynamic that I think is coming to a theater near you soon, like in the next 5 or 10 years. Half of the lawyers in the state of Washington are 50 years of age or older, and we're not being replaced. So, sorry.
Thank you. Fariba, you had your hand up.
I just wanted to confirm that based on this notice in Washington, the client of a triple LT is considered self-represented. Am I reading that correctly? This notice?
Yeah, pro se clients.
Okay, so they hired the triple LTs to do advocacy, to do their work pursuant to this program, but they're still considered self-represented, right?
So yeah, triple LTs can provide, they're independent legal practitioners and they can provide legal advice. And but in terms of, like I said, going to court and making a case, they're not allowed to do that.
But the program in Arizona, that's the major difference, is that they actually represent the client.
Yes.
Okay. Got
Can
it.
I ask for clarification, just following up on that for you, what about out of court? Because usually even in any like family law case, as soon as someone is retained, they'll file a notice that they're representing this client, even if there is no contested trial. So are you saying, Renata and Steve, that doesn't ever happen throughout the pendency of the proceeding, not just for the in-court part, the client who has hired a paraprofessional is considered to be pro se throughout the whole pendency of the proceeding? Is that accurate, or just in court they're considered to be pro se?
You know, yes, I think you're right. And whether that's the best way to go, I'm not sure. I think Dave is maybe in Arizona treading down a path that we would endorse. But again, I think it's a matter of how you sell the program and what you think you can get in terms of approval. I think personally, not speaking for the board, certainly not speaking for the court, the way Arizona is going is probably the way it should be. That there's a limited representation, you're limited within the scope of what you can do, but they in fact are your client. But you know, and that's why I think this whole movement and discussion is so vitally important for us to share ideas about what we did and why we did it and why you're doing what you're doing.
Okay.
Steve, this is Dave. I followed the Washington LLT program from day one to today. And wouldn't it be fair to say there was a real contentious battle between the bar and the justices on the court, went on for years. And because of that, a lot of compromises and structure were made. We avoided that in Arizona for a variety of reasons. Our bar, our document preparers are much more like the Washington LLTs. And when our document preparers program got started, it started out contentious, but it wound up being, I think our bar took either a supportive or a neutral position on that petition. So we didn't have the same historic battles with our bar over our document preparers that Washington did.
Well,
Okay.
and let me be clear, we're in I think, a blip, because 3 years ago, the Board of Governors unanimously supported the LLT program, made them members of the bar, and gave them an opportunity to have a seat at the table with regard to the Board of Governors. So it's a transitory process, and I guess it's wonderful we're all having this discussion to share our experiences.
So thank you, Dave, Steve, and Renata. I want to move on to Bonnie Huff with our California self-help guru. Bonnie.
Thank you. So I really, what an interesting discussion, and thank you. I was able to watch your video discussion last week, which was certainly helpful. And I do want to make it really clear that I'm actually not taking a position on any of these. I think it's a really interesting thing to be exploring and to be considering. So I think we did, when I was talking with Leah, we talked about a number of things that you discussed last week in terms of competence and political pushback and some of the other challenges. And also to kind of try to identify what the issue is. I'm not as sure that the issue in California is that we don't have enough lawyers. I think that the issue is expensive lawyers. Although, Steve, your point about lack of attorneys in rural communities is certainly one that is, I think is certainly one that we should consider in reviewing court files in rural jurisdictions. I certainly see much more evidence of LDAs than in other jurisdictions. But I think as we're thinking about it, one of the things I think we should be considering, and we started looking at, we don't have much evidence from Washington or Arizona yet, is sort of the cost of what this additional service would involve. And I did a little bit of research on it, but you might want to look at things like, what is the cost of having a accountant or IRS, the people who are authorized to go in and represent clients in tax matters and other kinds of things, just to get a handle on what those comparisons are and to get a little bit of a better sense. One thing that I think is important with this discussion is that the idea of the tiers that has been discussed. I think, Dave, absolutely. We went to Arizona to get ideas and started the facilitator program. I think it's also sort of dramatically expanded in California since that time. And we also have many document assembly programs and other kinds of things. There's sort of a range of services. But certainly people will often want to get additional support and assistance. And I think LDAs have done fine during this period, as far as I can tell. But there's a lot of assistance out there. And so and as I think I shared with you at the first meeting, when I'm looking at court files, there are very few files that I see where there isn't clear evidence that someone has helped them with their pleadings. There are just not a lot of people without any level of assistance. In researching, we're doing analysis on self-help centers, and there's a growing movement toward more settlement assistance, other kinds of things. So, and I think very many fewer uncontested hearings, so very few default hearings. So I think that I would encourage you, if you're thinking about people going into court, that they would be available for something that would be contested. I think it's fairly difficult to say we can only go in for something that's uncontested, because who knows, right? What's realistically going to happen, and you wouldn't, it's a little bit like a collaborative attorney who says, I can only help you with this portion of the case, and then if things change, the person has to hire another attorney, whatever, if what we're trying to deal with is a cost issue. Anyway, so what I have heard from judges, and I'll be really interested as you get more information, is that they would rather have an unrepresented person than a bad lawyer. That's the most difficult kind of situation that they deal with. So whatever we do, we want to make sure that that we provide LDAs with assistance and support, or whatever we call this paraprofessional class, with assistance and support, so that they can know the law, have basic information on court procedures and other support. So again, that goes, I think, to that tier kind of discussion. But for the most part, when I'm in courtrooms, what I'm seeing, and again, we're talking so much of the time about anecdotes. And the only benefit that I have is having seen many more, probably been in different courtrooms and having a little bit different perspective throughout the state. But I definitely see judges really working with self-represented litigants, asking questions, that kind of thing. And so I think my concern, as I've expressed it with Leah, is more in the unbalanced cases where one side has an attorney and the other doesn't, or there's another dramatic disparity. And so again, I would hope that whatever system we come up with really supports more balanced representation. So years ago, okay, so let's see. Yeah, okay, so years ago, about almost 30 years ago, I ran a program that provided support persons to victims of domestic violence under the statutory scheme for that. And what we found was that that was enormously helpful to have somebody there to support people, and that as the judge got to know, since we had volunteers who were doing it regularly, as the judge got to know those support persons, they might well ask questions or otherwise engage the support person more than might be in the statute. And so this goes to the sort of the concept that Fariba identified about the court having more leniency to sort of make those determinations. So I took a look at in England, they have a concept called a Mackenzie friend. And a Mackenzie friend can be anyone. honestly, that can be there in the courtroom to provide moral support, to take notes, to help with case papers, and to quietly give advice. That sounds frankly like a really wonderful, wonderful structure. They are not supposed to speak in court unless the judge is asking them questions, or to act as the person's agent, or work outside the court. It's really very much sort of a support role in the courtroom. In talking with judges in England, their initial response was, "I hate Mackenzie Friends." And then as we dug into it a little bit more deeply, their concerns were with people who were charging for this, because they were charging about the same as lawyers and didn't have necessarily, and there's no requirement there for training, for competence, that kind of thing. But what they said was that what they saw were many Mackenzie Friends who showed up and that were associated with nonprofits. And that again, they were seeing people that they saw on a regular basis, and that could be really helpful. And that the types they tended to see, for example, fathers' rights groups that would send a support person in on a child support or domestic violence kind of thing. And that although because the Mackenzie Friend was there to help them organize their papers and their thoughts, that they thought that those kinds of proceedings could go better once they realized the framework of the information that was being provided from the friend. But it's sort of an interesting kind of thing, again, to think about in terms of the paid model versus a nonprofit model. And I offer it as something to consider. Again, I think there are lots and lots of things that a paraprofessional can do. There's also another article that I sent on to Leah that was researching paraprofessionals in administrative procedures. And they were, again, with training and support, were able to do quite well. It goes to if you get trained and you're focusing on an area, you can get really good at it, right? Just like, and that may be a way to have representation in certain cases at a lower cost. I would encourage us to look at more of those kinds of models, like where out there are people providing representation, and sort of how's it working, but also what is that cost? So I don't know if that's, sorry, I'm not providing, I agree with Dave that I think that we have a lot of people who are flustered when they go into court, where it's challenging, and having somebody there to be at their side could be really helpful. And whether or not that makes sense for that person to be arguing the case is a whole nother matter. As I say, I just don't see a lot of uncontested cases in the courthouse. So it may be also sort of a difference in procedures.
Before we go on to take questions from Bonnie, I do want to now offer an opportunity for public comment. Just want to ask if there's any member of the public that wants to make a comment. Doesn't look like anyone's joined by phone, so if there is a member of the public that wants to make a comment, you can raise your hand at the bottom center of your screen. There's an option to raise your hand. I see we have Prescott who wants to make a comment, so go ahead and you can speak.
Thank you very much. Dave Byer mentioned fees. So my question would be, is it possible to have a commission possibly set up to structure a system of fixed fees or specific for specific services? Or in the alternative, maybe require them to give the client a written estimate of the cost that they would expect to have. We could, I was thinking about modeling after Business Professions Code 988-4.9, which provides that an automotive repair dealer shall give to the customer a written estimate price for labor and parts necessary to do the specific job. If the concept is, lawyers are too expensive, what is going to be the consumer protection in light of the fact that these people will have limited licenses, and it's sort of what the market will allow for. And I know, actually, I'm with California Advocates for Nursing Home Reform. We have a state bar lawyer referral service certified by the state bar. And I know that the attorneys that do the estate planning look at what the other attorneys are charging. When they find out, they raise their fees accordingly. So we get these information from the clients that will check back with us to find out, is that correct? So for instance, if a estate planning attorney is charging $350, $450 an hour, and then, what's to prevent, this new position, practicing law, from coming into like 100, 200, 300. So shouldn't there be some way to really protect the consumers and at least give them notice what they'll be charging, or in fact, set up a commission to say, for instance, a divorce, no contest divorce would cost this much, or you get the idea. But how can we really make this worthwhile for the consumers instead of just, creating another avenue for consumers to be paying too much for services? Thank you.
Thank you. Is there anyone else from the public that wanted to make a comment? Okay. Oh, wait, there is someone. Ira Spiro, who's a member of the working group, but is not on this specific subgroup. I'm going to invite you to speak now, Ira. I think I had the same problem with Ira that I did with Renata. It attempted to promote him to panelist, and he seems to have that. Oh, here he is. Okay.
Hello, can you hear me?
Yes.
I got bumped off, but I'm on. I just have a question. What, of Mr. Byers, what subject areas are proposed for the LLPs in Arizona? What areas of law, I mean?
Ira?
Yeah.
You're not a member of this particular group, and so you would need to participate as a member of the public, and I don't know that it's appropriate for you to actually ask questions. I think we'll be limited to making a comment.
Oh, all right. Okay, thank you.
I don't see any other members of the public that want to make a comment. So I think we can go ahead and if there is anybody that wants to ask Bonnie a question, a member of the group, or you can raise your hand as well. Stephen?
Bonnie, do you see any issue with starting the paraprofessional program without the in-court work and then adding that in as a feature maybe 2 or 3 years into the program? If you're going to add it at all, but not including it in the initial rollout.
Not necessarily. I think the question would be, what is the value add? What are you trying to do? What are you going to be adding with other parts of the project, right? I mean, we have LDAs, we have other services. So that would be my question, is I'd certainly want if you're making a shift, that it be something that would would really make a difference for the consumers.
Okay, and the consensus that, let me rephrase that. It had been suggested before that you were of the mind that this program, the paraprofessional program, had to include in-court work by paraprofessionals. That would be inaccurate, correct?
Well, I think, again, it goes to the what is the value add? What is it that you're going to do that will really make this useful? So that would be, as I say, I definitely am not in a position personally where I feel like I can make a recommendation on that.
Okay, thank you, Bonnie.
I'm learning and listening as all of you are, thinking about the challenges that consumers face, trying to think about what we could do that would make it cost effective and provide consumer protection and get it through.
Right. Thanks, Bonnie.
So it doesn't look like there's anyone else that has any questions. So maybe we can turn to a discussion among the members of the working group about this question of in-court representation to be provided by members of the paraprofessional program, and specifically with regard to family law. That's what we're limited to at this point. Anyone want to lead that discussion?
I can just kind of get the discussion started. Hi, Bonnie. Good to see you. You know, the Washington program, I heard Steve say that, and I'm reading this material, that the person is self-represented still. And Leo's question was a good one. Do they, as soon as they're in, they don't communicate with the other, if there's an attorney on the other side, they don't communicate with the other attorney, pre-hearing, meet and confer, and so on. And then it's for uncontested hearing. So there's really no arguments that they have to make. It's pretty much the hand-holding to make sure they provide the right information, the relevant information to the court, and the documentation. I definitely think there's a lot of value there that they can add, if I may use Bonnie's terminology. There's value added because I think a lot of self-represented litigants, even those that go through the self-help centers and family law facilitators offices, they still need that further hand-holding. Of course, you have a range. There are many functional self-represented litigants, and there's a lot of them that are not functional. As soon as they leave our office, they forget all of our instructions, even though they're in writing, and they just not functional at that level. And they're also emotional, right? There's a lot of trauma that they've gone through. So I think there's a lot of value added with the Washington type program. And so I wanted to open that up for discussion. Maybe we can compartmentalize our discussions, because I think representation in court and in contested cases is where we're gonna have more and more more opposition or more disagreements perhaps here. But what do you all think about that?
I'm really, really reluctant to have us be the first to roll out a new program that includes in-court work by paraprofessionals. And in Washington, they didn't do it until after the program had been in place for 3 years. Arizona sounds like, well, they don't know yet because they haven't rolled out the program yet. And I think a key word on what we heard from Washington was it had to be uncontested.
Right.
And I'm just having an expansive definition for paraprofessionals that includes in-court representational work. It dilutes what, I had people comment to me, why finish law school? Why become an attorney? Why pass the bar exam if you're going to be able to go into court? And I think it would be a mistake to do that as part of the initial rollout. I think we need to focus on helping people get paperwork done, advise what forms to fill out, and guide them through the process, and allow them to get legal advice from someone other than an attorney, but not let that person then be in court acting as an advocate or as an attorney.
Even if it's uncontested and there's no appearance by the other parties, more.
You know, I think if it's uncontested, as long as, you know, if they're doing the workup, there's nothing that says they can't be sitting behind the bar. And if there's a question that comes up, now that they're able to give legal advice, there'd be nothing inappropriate for that person to get advice from their paraprofessional in the courtroom. Just that person doesn't sit at counsel table or answer questions from the judge. I think that's got to wait till we know we can have a workable program. The other issue for me is the trust accounting. Like in California, it's what, $100,000 per claim that our bar dues fund, but we're paying $800 plus, if not $1,000 plus a year for bar dues. I can't imagine that that's what they're going to charge paraprofessionals, and they're going to have a pretty significant fee to fund their security fund if we're going to follow the same model for an in-court paraprofessional as we do for an attorney.
Anybody else?
It's interesting because I've been thinking a lot about this since our last meeting, and I think I was very much leaning towards, I guess, like everything that Steve just said. It's been interesting to listen to, especially the Washington program. It seems like they, to some extent, have some regrets, and now they're trying to push. 3 years later, they're like they've realized, like, hey, it would have really helped to have paraprofessionals be able to represent in courts. And it sounds like right now they have they're trying to take a second bite at the apple, and it's a little bit harder to try to push it right now versus if they had done it initially. I'm actually thinking that for the consumer, it may be helpful to have paraprofessionals in court, but maybe we need to define the parameters on when that's allowable and when not. That's how I'm leaning right now.
I blow really hard while I get you to lean the other way. No.
And it looks like Dana has her hand raised.
Dana? You're on mute.
You're muted, Dana.
I certainly was. I very much agree with what Sharon just said. I am extremely interested in taking a meaningful step toward closing the justice gap. And I was extremely moved by Dave Byers' comments and corollary with the medical profession. And I think it's important to trust consumers to know whether they need a PA, a nurse practitioner, or an MD. And I think it's very similar for us here. If I had an extremely complicated and high value case, I'm going to be able to, one, find a lawyer interested in taking it, and I'm going to give that to a lawyer. If I have something else where I'm extremely nervous about speaking in court, representing myself, I've already trusted a paraprofessional to prepare all the paperwork. I'm just not seeing the need for this bright line to keep them out of the courtroom or behind the bar. So I, like Sharon, am interested in finding ways where we can start this program with some in-court representation, because I'm worried that, like Washington State, if we draw a bright line, it's going to be harder to erase that bright line when we get down the road.
Anybody else?
Well, I can comment. So I too will reiterate that I would like for paraprofessionals to be able to give court representation. I think being able to give legal advice is already a step above from, what existing paraprofessionals can do. But we need to go higher, in assistance to close the justice gap. And court representation, I think, is where we should go. I also agree with maybe creating a system where only certain cases can be taken to court with the paraprofessional. Something along the lines of there has to be a mandatory settlement conference, and the paraprofessional can be at that settlement conference to hopefully again, keep everything out of the court so that they can have mediations, they can do stipulations outside of court. But I still think that we shouldn't be limiting the paraprofessional from, you know, helping completely. And I didn't mention this in the last session that we had, but the reason that sometimes I come across as very passionate, very upset, you know, I'm not. I just feel really strongly about my position on this working group. And like Leah said, it's really hard to get public comment to come here and tell their story. But the reason why I'm very passionate about this is because, you know, I'm Latina, a minority, you know, lower income. I didn't, you know, grow up with a silver spoon. And I found myself being a civil litigation paralegal working in a very top law firm and finding that I needed to be divorced, you know, due to, you know, reasons. And I was working in a law firm, made good money, but I couldn't afford an attorney. Also, I decided that I was going to represent myself because I had no choice. And that was very difficult. And every time I went to the courthouse, I left crying. You know, just getting documents filed at the court. I mean, the struggles you had to go through to just get the document on file, and then to be told that the doors closed at 3, the access center closed at 2, you didn't bring enough copies, and you know, and I had the legal experience. Now imagine other people that didn't. And that's why I built my business. I do uncontested divorces for self-represented people. That I left a good paying job at, you know, with retirement benefits, was there for 12 years to help people who were in my position because I saw the need. And, you know, it was like almost sometimes the blind leading the blind, because how can I tell someone else what to do? But it was just based off my experience. And even though, and you know, luckily I've been doing this for 5 years and my experience is great. And I have a lot of attorneys that reach out to me and they have questions and they need help, which box to check off. And so me, along with a lot of other LDAs, provide a great service to the public and to attorneys. And in this position, we're able to also provide access to legal resources online to the public, and also brochures prepared by attorneys. So like Dana mentioned earlier, there's a point where the customer can figure out what level do they need and at what time. So I just, you know, again, we don't really have much public comment. So I just wanted to let you guys know where I was coming from. In representing myself, there was a lot of times where I was hit with spousal support orders, because again, I made good money. I was hit with spousal support order, child support orders. The other person was represented, similar to Araya's story. You know, there was laws that I could not take advantage because no one was there to tell me, for example, that if you're a victim of domestic violence, you don't have to pay spousal support. I paid for a long time because someone didn't tell me that. So that's where I'm coming from. And, you know, I would have wished someone was there to help me with the paperwork, and just, it's about process and procedures. I don't need them to tell me what to do. At the end of the day, the decision was mine. And I just wanted to have that choice. And so, you know, the judge makes the final decision. The customer makes the final decision. Having a paraprofessional in the courtroom does not mean that, you know, it's a bad thing. It's a bad thing.
And if I may also to jump in, as not as a State Bar employee, but as a member of the public, as a consumer again. And I want to second everything that Elizabeth just said, because I also know how to fill out my paperwork. I knew how to submit it, but to have someone there that can speak for you and kind of put things in order for you when emotions are high and you're kind of nervous and stressed and don't know how to address the judge properly per se, it would be tremendously helpful. Otherwise, to me is like Bonnie said, where is the value? I mean, I can do my paperwork. It's just, if I don't have that representation and cannot afford attorney, then I don't know what would be the value be of someone sitting behind me. I had friends sitting behind me. So I just wanted to, I second what Elizabeth said.
Okay, I just want to say thank you to you, Arya, June, and Elizabeth for sharing your stories. I know it's personal and it's really helpful for us. Steve has his hands up.
He has his hand raised, and I would like to go ahead if you can keep it relatively short, because I think we do want to come to a decision. Yeah.
So the issue for me too is I do come from a different perspective. Unlike the other attorneys on this committee, I didn't graduate from law school. I read for the law. I finished my first year at Hastings, and then I did the law office study program for 3 years. Took the bar exam and passed it the first time I passed it. I paid my way through the law school I did go through. I paid my way through college. I typically was taking between 15 and 20 units and working 30, 40 hours a week. So I definitely don't come from a silver spoon background either, Elizabeth. And my perspective is there is so much damage that could be done in court for the one good paraprofessional that understands and puts in the effort that's necessary to do in-court representation. There's going to be 9 others out there that are going to do more harm than good. And we're not going to know about it until it's too late. You're going to have other cases where there's an attorney on one side, and I've dealt with this before, with people getting non-attorney assistance in advancing arguments that delay the case, cost both sides more money. I have other situations where people have gone to the equivalent, an LDA or to a paralegal or legal assistant to get paperwork done, and they end up getting an agreement that's set aside 6 months later because an asset was omitted or there wasn't an adequate disclosure. So for me, it's not an issue of we better put everything in the cart right now, because if we don't, we're not going to have a successful program. My concern is if you become the most aggressive state in terms of including this at the beginning without adequate oversight, without adequate anecdotal information, you may kill the program, because I think there'll be more bad stories than good if you make the program more expansive versus if you limit it to preparing documents and giving legal advice on issues like spousal support, giving advice on property issues, helping people get prepared for court to know what to say and when to say it, not to interrupt the judge. We're seeing this wide scale right now on Zoom hearings. I literally saw somebody draped over their couch like it was a Chase lounge during the middle of the hearing, or the guy that was self-represented holding his iPhone up in his bed while he was making a court appearance. Yes, Fariba. So there are things that we can do, and I'm in this for the long haul. I still think we need to have, when we do this, ultimately a trial program somewhere, and I want to do it here between San Luis and Santa Maria. One, because of the high need. We've got a very large Latino community in Santa Maria, and they do not get adequate representation right now. And this would be an area where I could oversee it, and we've got a law school nearby to do the training program. So anyway, I'll cut myself off, but I have more thoughts.
So if there is a member of the public who has their hand raised, I don't know if we want to invite more public comment. We really don't want to interject a member of the public into the discussion, but we can allow for the public comment if we want, or I've also advised the person that the public comment period happened earlier, but I know we probably want to come to a decision today.
It's closed. Well, I'd say that the public comment section's closed, and the other part is both comments we got were questions, not comments.
Right. Okay. So are we ready to?
Part of my group, like Calda. I don't know if you guys would allow.
Well, I think we want to go ahead and maybe come to a decision on this question. I want to ask if the group feels like you're ready to come to a decision on the question of in-court representation in family law proceedings. And I think a decision could be made just on that threshold question, and then if the decision is to include it, then well, if the decision is to not allow for any in-court representation at all, then we just move forward with what would be allowed. If the decision is made to include in-court representation, then there would be further discussion at future meetings about the scope. So,
I think we're going to.
But if you think you're not ready, then we can, you know, we can go ahead and push this decision to
I
a
think we're going to
future
have a
meeting.
split decision, Linda. I think it's going to end up being with the subgroups on the wobblers, where we're going to have two competing memorandums.
Okay.
And I think that we need to flush out, I hate to, you know, take everyone's time for one more meeting, but I think we need to flush out the definition of representation and the benefits of limited representation. You know, we've heard a lot here, and there is some good to come out of certain level of representation versus advocacy in court and with complicated issues. How do we limit that? Is an artificial limitation. We could, you know, if you're in the middle of a hearing and you cross over to the part that you're not supposed to touch, how do you stop? So there are, I think that if there's one more meeting, so at least if we're going to have a split vote, we have had some meaningful discussion to try not to have a split vote. And I would vote for another meeting to just kind of digest what we heard today, what we know about Washington, about Arizona, and then kind of come together again and try to just the committee members to try and hash it. I think Leah said somebody from Consumer Affairs Department is supposed to come next time.
Well,
the general meeting.
They're coming to the general meeting.
Oh,
They're not a member of this group.
Okay.
So, although if you want to bring this person in as like a subject matter expert to ask questions about the program, I think that's a possibility.
Because to me, I really want to know about, and again, I said that last time too, or said this last time about putting the cart before the horse. I want to know about training. What is the plan for training programs? What is the plan for oversight? What is the plan for required insurance, CLE, and disciplinary measures, you see? So I really need to have that information in order to confidently take a position. Because if I don't know about that, then I'm, you know, I work at the self-help center. I run the self-help center, and we see thousands of people, and I see a lot of abuses out there. As early as this morning, somebody just kind of charged to do some forms wrong. And Elizabeth, I know there are really a lot of good document preparers out there. I know that. But I also see a lot of notarios that charge their clients for doing absolutely nothing. And I've tried to encourage the person to go report that person, but there's really not a lot easy reporting right now. So I'd really like to hear from the Department of Consumer Affairs. And if the state bar is going to regulate and it's going to be a complaint line, kind of like for attorneys, I'd like to know that too. So I think I care enough about this, and I think there's really value to it, but I want to know that information before I make a decision.
So I'd like to respond with two things. One is that we can certainly invite, if the group would like, the new member who's with the Department of Consumer Affairs to the next meeting to ask those questions. In terms of regulation and education and the path to certification, that's going to be like the next step. I don't think we're going to be able to flesh out all of what's going to be included in that with this group. That's sort of the next step that the working group is going to be undertaking. What are going to be the requirements for licensure, and where is the regulation going to reside? Your recommendation could, if you're going to go in that direction, the part of this group that wants to recommend in-court representation could specify in its recommendations that there's going to have to be really stringent education and experience requirements, but I don't think we're going to flesh those out in advance of making a decision on this question.
Basically, to reiterate the way else I understand it, to just as a follow-up, is that you as a working group would decide that. So like where Arizona said they have to go through, they have to specify the legal area, for instance, and then they have to take the exam and pass it. They have to have a minimum education. They have to have CLE afterwards. They have to go through moral character and fitness, and they will also have the same disciplinary consequences if they do something wrong. So, I mean, I feel like it would be within the power, if I'm mistaken, please correct me, within the power of the working group to set those parameters, to be strict or not strict, or have those kind of milestones that they have to reach before they can represent someone.
That's correct.
I know that our time is up because I have to join another meeting. I think that we need, like, I know that we're running up against a deadline, but we need more time to flesh this out. Family law is the #1 need. And I think we spent a lot of time listening to Arizona and Washington, and we need some time to digest this and more time to have meaningful conversation. And I would like to hear from Consumer Affairs.
Okay, so our next meeting is next Tuesday, the 18th. So I will invite, it's Kimberly Kirkmeyer, who is the director of the Department of Consumer Affairs, who, as Leah mentioned, is joining the working group. I will invite her and see if she's available to join the meeting.
Hey, Linda, we're
Tuesday.
set at 2 o'clock for that meeting, right?
Yes.
And then we're expanding these subgroup meetings to 1.5 hours because we never can get enough done in an hour, right?
That's correct.
Okay, I just changed it on my calendar. Thank you.
I think I sent an update to make it 1.5 hours. Did everyone get that or not?
I did, yeah.
Okay, great. Okay, well, thank you.
Thank you. Bye. Meeting adjourned.
Bye.
Bye-bye.
Thank you.